My name is William Corbett. I'm an attorney and professor of law at the University of Montana Law School in Missoula. I have been appointed by the commissioner sitting to my left, Dennis Unsworth. He's the commissioner of political practices for the state of Montana. I've been appointed as a hearings officer in this case. Commissioner Unsworth is here, and a staff, a staff member from his office is also here. I have a prepared sort of introductory comment to make, but I want to sort of deviate from that for a moment, just to make sure everybody understands. We're going to hear today only from the attorney representing the governor and the attorney representing the Republican Party. This is not a hearing where I'm going to take public comment, and no one is going to testify here today. So I'm just going to hear from the two attorneys on a very narrow motion that has been filed. The proceeding that you're going to hear today is the matter of the complaint of the Republican Party concerning Brian Schweitzer. The Commissioner of Political Practices for the state of Montana is authorized to receive complaints against Montana public officials and employees. The matter we are hearing this morning is such a complaint. The complaint was brought on April 8th of this year by Jacob Eaton, the Executive Director of the Montana Republican Party, against Governor Brian Schweitzer. The complaint alleges that the governor, as a candidate for re-election, violated certain ethics laws. Generally, the complaint concerns the preparation and distribution by the governor of two recorded announcements that were sent to several Montana radio stations. The preparation and distribution was made after the governor filed for re-election. After the complaint in this matter was filed, the attorney for the governor filed a motion for summary judgment. And that's what we're hearing today. This motion filed by the governor, a motion for summary judgment. In the motion, the attorney for the governor acknowledges that there was a preparation and distribution of two recorded messages, that the preparation and distribution was assisted or performed by Sarah Elliott, a member of the governor's staff, and Ron Ziegler, the public information officer for the Montana Department of Agriculture. That the recorded message featured the voice and identification of the governor, and that it was prepared and distributed shortly after the governor filed for re-election. So those are the facts that we know. We're going to hear from the attorneys a little bit later in terms of whether there are other disputed facts in this case that bear on the motion before me. In this motion, the attorney for the governor argues that based on the facts that I just gave you, there was no violation of Montana ethics laws. And there's only one ethics law in controversy here. There isn't a multiple of violations. There's only one ethics law. The attorney for the governor argues that because the relevant facts are clear and undisputed, there is no reason for me to hold an evidentiary hearing in this matter, that based on the facts that I previously mentioned, that the press message that was recorded and distributed by the governor was either lawful or unlawful, and that a determination on that legality can be made without holding a further evidentiary hearing. Indeed, if the facts are not in dispute in this matter, the governor and his attorney are correct. There would be no reason to hold an evidentiary hearing. And the legality of the governor's action could be decided as a matter of law. Alternatively, the governor for the Montana Republican Party argues that the facts surrounding the event are not clear, that the governor's motion for summary judgment should be denied, and a hearing to gather evidence about the recording and distribution of the press messages should be scheduled. So that's what we're talking about here. We're just talking about whether we're going to schedule a full-blown evidentiary hearing. The Republican Party says we need such a hearing. The governor and his council says there's no reason to hold such a hearing. The governor and the Montana Republican Party do not agree on the interpretation of the ethics law in question. So one of the questions will be is, what is the proper interpretation of the law? The parties don't agree in terms of what is the proper interpretation of the law, and we're going to hear from them this morning about how they each interpret the law. However, regardless of their different interpretations of the law, if the relevant facts surrounding the press message are not in dispute, there is no reason to hold an evidentiary hearing. The hearing would be solely for the purposes of determining the fact, and there would be no issue of fact outstanding, and the matter could be decided as a matter of law. In today's proceeding, you're going to hear from both attorneys what they believe are the facts surrounding the recording and distribution of the press message. I counsel you, these statements of the attorneys are not considered by this tribunal as actual fact or as evidence. But there will be an attempt on the part of this tribunal to ultimately figure out what are the facts that are agreed to and potentially what facts are not agreed to. And in terms of those facts that are not agreed to, whether there's a need for an evidentiary hearing. That's what we're here today to decide. And I'm going to hear from the two attorneys on this limited motion. And let me ask, is counsel for the complainant ready to proceed? Is counsel for the governor ready?
We are.
Okay.
Your Honor.
Thank you. And in terms of the allocation of time this morning, I'm going to give the governor's attorney approximately 20 minutes to make his opening presentation. That will be followed by approximately 20 minutes by counsel for the Republican Party, and then counsel for the governor will be afforded about 15 minutes in terms of rebuttal. So how we're proceeding is we're going to hear from the governor's counsel. We're hearing from the governor's counsel because it's the governor and his attorney who has filed the motion, so I'm hearing them first. Then we'll hear from the Republican Party, and then the governor would be given an opportunity for rebuttal. And that is the normal procedure in how you hear motions like this. Counsel, you may proceed with your statement.
Professor Corbett, Commissioner Unsworth, my name is Michael Loy. I represent Governor Schweitzer in this matter. I think that I should say as a prefatory note that both counsel for the Republicans and myself will refer to you as Your Honor throughout this, and that's just a matter of rote, and I hope that you take that more as a compliment than as a foul on our part.
No, and I will take that as a compliment, and I promise you I will not require you to repeat that in any other setting that we may encounter. And I will let it go.